we have just a few more minutes. We have one more case to talk about. And so this was Radaszewski versus Telecom Corp. And it's another accident case. So what happened here? All right, so our friend Radaszewski was riding his motorcycle. My dad calls them donor bikes, right? So I don't know if any of you drive one. Drive carefully, especially in the rain out here. And he was seriously injured by a truck driven by an employee of Constructs, right? I mean, driving a motorcycle is an assumption of risk, but he didn't assume this risk. What happened to him was that he sued Constructs, and he is an involuntary creditor. Now, the jury decided he was entitled to damages. He was not at fault. I mean, you take some assumption of risk by riding a motorcycle, but not the risk of getting hit by a truck and not paid for it. So the jury finds that Conrad Radaszewski is deserving of money. So what happens to the money? Well, Constructs doesn't have much money. It's not heavily capitalized. It's minimally capitalized like most businesses are. It's actually a subsidiary, but it has insurance. They had the mandatory statutory insurance. However, their insurance company went bust. And what happens to our friend Radaszewski? Well, he's left holding the bag, right? He's injured, and he's deserving of compensation. And the system is not giving it to him. So he sues. And he sues on the theory that he should be able to pierce the corporate veil in the upward direction and go after the parent company, Telecom. Telecom owns the insurance company as well, by the way, although that doesn't seem to make a huge difference here. So the question is whether, under Missouri law, Radaszewski could pierce the corporate veil and hold Telecom liable for the conduct of its subsidiary. And it turns out that the rules for a corporate parent versus an individual shareholder really aren't different. Right? This is a little different in that at the top of that is not an individual, but another company. But the court doesn't seem to care and finds that, no, we're not going to allow piercing in this context. Why? Because it wasn't being treated as an alter ego. It wasn't undercapitalized. It was minimally capitalized. It wasn't having any wrongdoing. It was operating properly. It had no reason to know. I mean, why would anyone buy insurance deliberately from a company that's going insolvent? That didn't make sense. There didn't seem to be any wrongdoing there. And the court cites a case that you should know of. Collett versus American National Stores. You don't have to cite to Collett. You can cite directly to Radaszewski, but it sets out 3 things a plaintiff has to show in order to pierce. So what is our 3-part test? First prong of the 3-part test is control. And not just any control, but here they mean complete domination. Complete domination not only of finances, but of policy, business practice, in respect to the transaction. So much control, in fact, that the burden is on the plaintiff to show that the corporate entity at the time and as to this transaction had no separate mind, was completely dominated by the parent or the shareholder. And 2, that control was used by the defendant, by the shareholder, by the parent to commit fraud or wrong, to perpetuate the violation of a duty or other positive legal duty. Okay, high burden, right? To actually show that that control was used to create wrongdoing. And 3, that control and breach of duty proximately caused the harm. So that's the 3-part test set out in Radaszewski, which is known as the alter ego doctrine. It is not the only way under which you can pierce. As I mentioned, there is no one standard for piercing, but this was a particular kind of liability called the alter ego doctrine, essentially saying that the subsidiary was not different from the parent at all, was completely dominated from it, had no separate mind or existence of its own, and that control was used to perpetuate, commit a fraud or wrong, and that fraud or wrong proximately caused the injury. That is the alter ego doctrine. So, Radaszewski argues that Constructs was undercapitalized, and that goes to the second prong. How is undercapitalization something that the defendant uses to commit fraud or wrong? Well, the district court agreed with the argument, so we can look to that for that and say the district court found that Constructs was undercapitalized in an accounting sense, and although it had some amount of money, it did not have enough to satisfy its debt in this case. So the district court took a very narrow view, and by the way, spoiler alert, it was overturned, took a narrow view and said because you couldn't pay your debts in this instance, they had $10 million in coverage and $1 million in basic liability, and that wasn't enough for reasons that turned out later in hindsight. The district court held that the federal regulation did not say what was enough, but in this case it was proven not to be enough with the benefit of hindsight. Well, the Eighth Circuit reversed and restored us to a state of the world that looks a lot like Walkowski. The Eighth Circuit disagreed and said the whole purpose of asking whether a subsidiary was properly capitalized was to determine its financial responsibility. If the subsidiary was financially responsible, the part of the test, the second part, was met. If you're being financially responsible, you are not committing fraud or wrongdoing with your financing. And so insurance should be enough. In fact, insurance in some ways is better because it could potentially cover much more. I mean, if you have $100,000 in the bank, you can get a lot of insurance for that, depending on what you're doing. You might get $10 million in insurance versus $100,000 in the bank. That could really help our motorcyclists in getting made whole. And so they don't distinguish between insurance and cash in the bank, so long as they're meeting their requirements. And it was beyond dispute that Constructs had insurance, and therefore it was considered financially reasonable under applicable federal regulation. The court found the doctrine of limited liability was developed precisely for this situation, to protect a parent from a subsidiary who goes broke. To protect a parent whose subsidiary goes broke. That's the point of the doctrine. It would be destroyed if every parent corporation would be liable every time a subsidiary did not have sufficient funds. All that Radaszewski showed in this case was at the end of the day they didn't have enough money to pay him. Well, that happens. We can have a different conversation, going back to corporate social responsibility, purpose of corporations, whether that's fair that we allow corporations to externalize risk, but they do. Within bounds. We have not exceeded the bounds yet. We still have not seen a case. Now, the senior circuit judge, Heaney, disagreed. Heaney argued that Contracts was just a shell corporation, and it was established by Telecom only to allow Telecom to operate as a non-union carrier. Contracts is driving around, they don't want to employ union people. Telecom, I guess, had union contracts or was susceptible to unions, and Judge Heaney actually argued that they were avoiding union laws. Now, I think that one reason that argument doesn't hold water is because it doesn't meet the third prong. What's the third prong? The third prong is that the control and breach of duty must proximately cause the injury. If Telecom set up Constructs to avoid paying union dues, did the failure to have union members cause the harm? That's much more attenuated. Now, it's possible you might find some argument that union drivers are safer. Maybe union truck drivers are safer because they get more breaks and are paid more, or what have you, or it's harder to be selected for, and so that would reduce the risk of harm. That argument was not successful. That's way too attenuated. And so I would disagree with Heaney in that he did not address the third prong of that argument. But, you get these kind of cases where you feel bad. Someone gets terribly injured in a motorcycle accident. You'd like to see them made whole. But I think the court rightly held, the Eighth Circuit rightly held, that that was not the correct result in this case. Undercapitalization is not inherently even unlawful. It depends on the reason for doing it, right? Going back to that alter ego test, the second prong is used to commit fraud or wrongdoing. Some courts have inserted a scienter, an intent requirement to that prong. Now, you don't have to necessarily go that far. Not all courts have adopted it, but again, there's not a clear standard on this, which means that piercing is more appropriate if a company is deliberately or recklessly creating a company that cannot pay its bills. If you're simply negligent and you don't maintain enough capital because you're dumb or lazy, that's not enough to rise to liability if we have a scienter requirement. Not all courts will take that approach. So is this different than the test used in Walkowski? Not really. The result would be the same, but this one is a little bit more structured. And as law students, you may prefer a more structured test. Now you have one, right? You have three prongs that you can evaluate, one leading to the next. And so I would suggest that if you're going to address piercing in torts cases, you can adopt the alter ego test because it's a little easier than just throwing all the factors into a big soup as Walkowski did, but either test would result in the same result. All right, so Last few things. Yes, sure.
Quick question.
Yeah, of
How
course.
would vicarious liability factor into the whole control factor, the second prong?
Vicarious liability of the...
So, of an employer and agent, or what does not even matter?
So the vicarious liability would pertain to an employee and an agent within an organization,
Yeah.
but not, it does not, you would need a separate veil piercing to go up the chain. If, however, Telecom did more than own Constructs, but actually directed it, if Telecom hired a Constructs driver to whatever, and maybe said, we need to get that, I don't care if the speed limit's 60 and it's snowing, you're doing 80 because this shipment of telecom equipment needs to be delivered. There we could see an argument for liability, but here this was a totally separate operating entity, and so vicarious liability wouldn't apply since there wasn't that agency relationship.
So I mean, like between the parent and the subsidiary, that control needs to be there, period. And
In order for there to be vicarious liability, you have to actually be directing a person to do a
Yeah.
task, as opposed to simply owning a company, right? And so, I mean, likewise, like you're let's say you go back to Microsoft, you may be a shareholder of Microsoft, right? That's different. That relationship changes, however, if you start engaging with some member of Microsoft to do a certain thing. And so long as you maintain that appropriate role of the shareholder, sort of just voting for the board and electing them, the board then will make decisions for the company. And even their liability will be limited. The CEO who sent the driver out, maybe some liability for him there, and that's why we have insurance and things like that. So what is the argument then for enterprise liability? Why would we create a situation where you're liable for your parent companies? Well, it expands assets to corporate creditors without imposing liability on the shareholders. So some will favor enterprise liability, even if they don't favor individual liability, because it allows more collection, but it still doesn't go to individuals. We'll talk about that a little more when we get to corporate groups. But it doesn't actually matter in Walkowski. Why? Because the other corporations in this economic unit were likewise undercapitalized, if you will, or minimally capitalized. So what kind of advice do you give your clients after learning this? Now, I'm not talking about contracts yet, different set of advice for your clients with regard to contracts, but if your clients are a corporation, or corporations, and they do things that can result in tort liability, what should they do to protect the shareholders? Well, let's take a look at the factors and flip them, right? What would we do? How would you advise, for example, the owner of a taxi fleet to organize the business? Well, one thing we learned in this multiple corporation structure was respected. You probably should have a different company for every cab and maintain the minimum amount of insurance, because apparently maintaining minimum insurance is enough. You're not undercapitalized, you're minimally capitalized, but that's enough. You don't have to worry if you're minimally capitalized, it's not undercapitalized. So we'd advise the client set up a multiple structure. In fact, when I work with clients who are dealing real estate transactions, I always encourage them to look at a series limited liability company, which allows you to do this without multiple filings. Talk more about that at a different class. But in any event, this multiple structure generally works, but it only works if the corporations act like separate entities. And that means that you need to observe corporate formalities, and you know how to do that now because what we studied in authority and how corporations grant authorities. That's a fundamental lesson that fits into here. If they're not observing formalities, much greater risk of having them commingled. And again, commingling, you don't want to be dipping in the till. Make sure there's that separate bank account, and not just a separate bank account between the owner and the companies, but that means if you want these companies to be treated separately, they each need their own bank account. Right? Any commingling can result in those two being seen as the same entity. So if you have companies A, B, C, D, E, and F, and there's only one bank account, you're now running a risk of having enterprise liability. And so you tell your clients, no, you need a separate bank account for all those cabs. That's more important even than having separate assets. They shared a garage, for example. There was some common plan to all this. That increases the risk a little bit, but bank accounts are the biggest thing. And you might tell the founders come to you and say, we kind of ran over this guy. I think a lawsuit might be coming. Can I issue a dividend? So no, that's a bad move, right? So if there is a big liability coming, a big contract coming due, you ran over a pedestrian, et cetera, and the client says, you know, I'd really like to avoid liability for this. The company has $1 million. I really did this guy a solid, so like I'm probably going to be hit up for that. Can I take that money and issue a dividend? No. We go back to some of the concepts about fraudulent conveyance there, but also if you're shuffling access, the New York court would more likely pierce in that case. So to wrap it up then, when we learn about piercing, we talk about these first two cases. How are they similar? Well, in both cases, we're talking about involuntary claimants. Tort claimants are, by and large, involuntary. And we're talking about operating companies that had minimum insurance. They were not underinsured. They were not well insured, but they had the minimum insurance required by law. In both cases, we had a wholly owned subsidiary dominated by a parent, right? Similar structures. And we find a conclusion that piercing is not appropriate. And I'll add to that, in both cases, we have a finding. We have no evidence of commingling assets. We have no evidence of not observing corporate formalities. And so we have the absence of those plus factors. There were some differences. Radaszewski is a parent to a corporation. And so even if there was piercing, shareholders themselves would not be liable. But that didn't seem to make a difference. We're still going to protect interest even for corporations. Radaszewski was really trying to get at an enterprise liability concept, but the court applied the same doctrine. Should we then, is this right? Should we protect corporate owners in the same way as individual owners? Well, the court seemed to. But you can think about whether or not you think that's fair. Because you can insert many levels of corporate interests, one on top of the other, like a set of, those Russian dolls. There's only a little one inside. Whereas there's a limit to how many natural persons can be sitting on top of this. And do we achieve the purposes that limited liability is meant to achieve by protecting corporations the same level as people? These are open questions. So then, why should the internal operations of the corporations be relevant for torts? I mean, it's not like the company authorized running over some guy, right? They didn't have a board meeting and say, okay, let's go run over Carlton. Let's go run over Walkoski today. That wasn't an authorized decision. So why do we care about books and records? Well, some have argued that if corporate formalities are flouted, it signifies that the company is not being run as a business, but as an alter ego. And it helps the court give a reason to hold a person liable. It's kind of a quid pro quo. I mean, having a corporation is a bargain. You get certain liability privileges, certain immunities, and you have certain responsibilities for it. So while the argument does not hold as much weight as we'll see as it does in contracts, courts will still look at whether there has been a flouting of corporate formalities.